Number of unethical attorneys pushing revocable living trusts to protect their assets from probate. They are too complicated, overpriced, and misleading. Maybe 1% of the country should consider them. They are oversold. Yes, a revocable living trust can help avoid probate, but there are negatives and limitations. The biggest problem is that people think that trust automatically avoids probate. It does not. It only avoids probate for assets that were properly transferred into the trust or correctly named to the trust. If the house, bank accounts, or brokerage accounts are still in the person's individual name, the family may still need probate. New York guidance notes that probate may still be needed unless virtually all assets are in the trust or otherwise pass outside probate, such as joint ownership or beneficiary designation. Main negatives. 1. It costs more upfront. A revocable trust usually costs more to draft than a simple will. You also usually still need a pour-over will, a power of attorney, a healthcare proxy, and a beneficiary review. 2. It must be funded. This is where people mess up. The trust document by itself is not enough. The home deed, accounts, and certain assets may need to be retitled into the trust. If this step is skipped, the trust may be mostly useless for probate avoidance. 3. It does not protect assets from nursing homes or Medicaid. A revocable trust is still under your control. Because you can change it or revoke it, the assets are generally still treated as yours. For long-term care protection, people usually discuss irrevocable Medicaid asset protection trusts rather than revocable trusts. 4. It does not protect assets from your creditors. Because you still control the trust, your creditors can usually still reach those assets. New York Trust Commentary commonly notes that assets of a revocable trust remain available to the settler's creditors. 5. It does not avoid estate tax by itself. The American Bar Association explains that revocable trusts do not help avoid estate tax because your power to revoke or amend the trust means the assets remain includable in your estate. 6. It can create false confidence. People think, I have a trust, I'm done. But if the beneficiary forms are wrong, the deed was never transferred, the accounts were not retitled, or the successor trustee is poorly chosen, the family can still end up in a mess. 7. It may be unnecessary for simpler estates. Some assets already avoid probate. Life insurance with named beneficiaries, retirement accounts with named beneficiaries, joint accounts with rights of survivorship, and certain payable on death or in trust for accounts. Law Help NY points out that other estate planning devices can avoid probate as well, not just living trusts. 8. It does not name guardians for minor children. A trust can control money for children, but a will is still typically needed to nominate guardians. 9. It creates ongoing paperwork. You may need to update titles, keep records, notify banks, manage trust accounts, and make sure new assets are titled correctly. Many people create trust and then never maintain it. 10. Banks and institutions can be a headache. Some banks, brokerage firms, or title companies may require extra paperwork before accepting trust documents. This can slow things down during life and after death. My honest take, a revocable living trust is not bad. It is just oversold. It is best when someone owns real estate, wants privacy, wants smoother management if they become incapacitated, owns property in more than one state, or wants to avoid delays in surrogate's court. For a simple family, sometimes the better basic plan is will plus power of attorney plus healthcare proxy plus living will plus correct beneficiaries plus TOD/POD accounts plus life insurance beneficiary review. A revocable trust can be added when the estate is large enough, complicated enough, or real estate heavy enough to justify it.